Okay, our next case is Hubbard versus State of Florida, number 2024-1522.
Good morning. May it please the court, Mr. Chief Justice, Craig Trocino and Michael Gotautle on behalf of Mr. Hubbard. This case is not about elections or the severity of the alleged crimes. This case is about constitutional authority and the constitutional allocation of power. The Office of Statewide Prosecutor is a creature of the Florida Constitution, and when that amendment was enacted, the Florida Constitution put the Office of Statewide Prosecution in a constitutional box, and that box has borders, and this case is about exceeding those constitutional borders. This court has held for quite a long time, most recently in the Ham decision, that the interpretation of constitutional amendments is based upon the supremacy of the Constitution when it conflicts with state statutes. In the Planned Parenthood case, this court has stated that when we interpret those constitutional amendments, the plain text of the constitutional amendment is interpreted by the text, but specifically by what the voters would have interpreted the text at the time it was ratified. This statute was ratified in 1986 by the voters of the state of Florida, pursuant to the Constitutional Convention, directed by Governor Graham, and in that created the Office of Statewide Prosecution. All of the debate, editorial, discussion at the time was about the Office of Statewide Prosecution investigating and prosecuting complex, organized crime. Nowhere in any of that discussion or in the minds of the voters in 1986 was there a discussion of single circuit voter cases being handled by the Office of Statewide Prosecution.
Counsel, how did the District Court of Appeal pass on the question, or how did its decision pass on the question that's been certified to this court?
How did the District Court of Appeal pass on?
How did the decision pass on the question specifically put to this court, which is a very general question of whether the statewide prosecutor can prosecute crimes relating to registering and or voting in a statewide election, which seems to actually be expressly stated in the statute itself?
Well, first off, the 4th District Court of Appeal in this case did not address the constitutional issue at issue. The conflicted cases that are pending the resolution of this, Washington and Hart and so forth, did. The question of whether the statewide prosecutor can answer this, the 4th District Court of Appeal, in our opinion, incorrectly concluded that they could, and they incorrectly concluded it for a few reasons. One, they rested primarily on this idea of effects, the effects jurisdiction.
But that goes to the other portion of the statute, as to whether this activity happened across different circuits.
Well, it would have to happen across different circuits in order to implicate the Office of Statewide Prosecution.
Sure,
if it's purely
but the general question of whether they can prosecute registering or voting in a statewide election, that's true if the activity passes across.
Only if the activity crosses, correct, yes.
But that's not the question that's been put to us.
The question that's been put to us is, well, not us, Your Honor, and the court, is whether the Office of Statewide Prosecution can prosecute these cases. And the statute...
Generally speaking.
Generally speaking, yes. And it's an overly general thing. And the jurisdiction of this court is once this court accepts jurisdiction on some aspect of it, it accepts jurisdiction on all aspects of it. So I believe the constitutional interpretation that the 4th District Court of Appeal neglected to engage in is squarely before this court.
I think he's asking you, though, because in order for us to have jurisdiction, it's not just a matter of is a question posed, it's did the lower court pass on the question that they're posing.
They did.
And, okay, so yeah. So that's what you have to answer.
Correct, and they said it was okay. The 4th District Court of Appeal said the Office of Statewide Prosecution can prosecute these cases, and it gave reasons why it could prosecute these cases.
Well, but these cases would be in the general category of, because it's expressly listed in the statute that they can prosecute these cases. So I don't understand how that would have been in dispute with the DCA. What was in dispute in front of the DCA was, in this particular case, whether there were facts that showed that the activity crossed judicial circuits.
Well, as it existed at the time in the 4th DCA, the statute in effect at the time was voter crimes that occur occur in 2 or more circuits as part of a related transaction, or affect 2 or more circuits where there's a criminal conspiracy. That was the statute pre-amendment. That was the statute that was in effect at the time. The stipulated facts here are that there is no criminal conspiracy. So as it existed at the 4th DCA, without getting into the 2023 amendment, the only question that is germane, because effects doesn't exist, because there's stipulation that there's no criminal conspiracy, would be the related transactions sections. Now, yes, I agree with Your Honor that the statute does seem to say that, but there's a couple of problems, and that's where the 4th District Court of Appeal, in our opinion, made a mistake, in that in order to, from a constitutional point of view, in order to activate the authority of the Office of Statewide Prosecution, there has to be multi-circuit impact. There has to be a multi-circuit transaction, crimes in both circuits in a related transaction. That didn't happen here. So irrespective of what the statute says, if the statute is saying that all voter crimes can be prosecuted by the Office of Statewide Prosecution irrespective of multi-circuit situations, then our opinion is that that would be blatantly unconstitutional.
Why?
But, yes.
Why? What would be unconstitutional about reaching the conclusion that any time a voter crime relates to the validity of a federal or statewide election, it is a permissible subject for the Office of Statewide Prosecution, especially after the 2023 amendment to the statute? What is blatantly unconstitutional about that?
Because the Office of Statewide Prosecution has to have across 2 or more circuits. I understand.
So let's stipulate, right, that
okay.
I mean, unless you're going to make the argument that the disenfranchisement of one voter is not a statewide effect in a federal election, because we have to reach some level or sort of tipping point of votes for this to count. It would seem to me that if in fact it is a statewide or federal election, the improper exercise of the franchise, which has the effect of disenfranchising others on even one occasion, would be a statewide effect. Tell me why that argument, which the state makes, is somehow unconstitutional.
Several reasons. First, the state did not preserve that argument. They never argued that.
That doesn't go to constitutionality. Why is the argument? You said blatantly unconstitutional.
Because the effect. Now, in order to answer Your Honor's question, and getting the temperature of the room here, I think this is what it all comes down to, is how do we define the word effect? Your Honor is saying that any incorrectly cast vote, therefore, must affect all other circuits. If I'm
asking you to tell me why it doesn't.
Right, I'm getting there. I just wanted to make sure I understand Your Honor's question.
Okay.
Right. That is far too ephemeral and tenuous for the purposes of the statewide prosecution. For instance, as Judge May said in the dissent in the 4th District Court of Appeal, if that's the case, then any driver's license offense is statewide. If that's the case, if that's the case, a workers' compensation fraud will affect.
Your position is that I think we're getting a field of an election, right? An election has a statewide. Let's stipulate we're talking about an election for governor.
Okay.
Okay. You're telling me that's not distinguishable from driving with a suspended license from Leon to Alachua County, and I mean, it would seem to me like one clearly has a lasting impact on the outcome of an election. We've seen pretty close elections in Florida. It would seem to me like we can distinguish the driving without a license. You're saying that those are indistinguishable from your perspective?
I'm saying that the concept that one isolated vote has a broad effect statewide, as the 4th District put it, would diminish the public's confidence in the outcome of the elections. If we have that, and I understand, and it's a concern, I'm not trivializing this. I opened with saying this is not about the seriousness of the alleged offenses. However,
what I still haven't heard is why it's blatantly unconstitutional for the Office of the Statewide Prosecutor to try.
Because the test on whether, under the statute, under the Constitution, the test for whether the Office of Statewide Prosecution can act is not whether there's a reduction of public confidence in a particular realm. It is whether a crime was committed in 2 or more circuits, or a crime was committed that affects 2 or more circuits if there's a criminal conspiracy. That doesn't exist here.
Can we just get, I think, let's make sure there's a meeting in the minds here. Okay, on the constitutional side, there's the occurring in 2 or more circuits as part of a related transaction.
Correct.
Right? That has nothing to do with effects, and has nothing to do with the 2023 statute.
Correct.
The second part of it is, if the 2023 statute is essentially implicitly saying that us voting in a statewide election has effects in more than one circuit, then that might raise a constitutional issue, right? So but for us to even worry about effects, we would have to think that the 2023 statute applied. And so can you just can you focus on the first part, which I think is really the heart of this thing, which is the occurring in 2 circuits or more as part of a related transaction.
Okay. Which
I think is sort of that's kind of the threshold thing. And then in order for the effects thing to be relevant, we'd have to decide that the 2023 statute applies. And that's a completely different constitutional question, right? I
agree. Yeah, so as far as the related transaction is concerned, I don't believe there's a case in Florida where related transaction jurisdiction was found to have happened where there wasn't criminal activity in both. The state relies on King, and the state relies on Snyder. And in both of those cases where the related transaction jurisdiction, if you will, for the lack of complicating the issue, where those were found, there was criminal activity in both circuits, in both disparate circuits. Here, it is stipulated in the stipulations at trial that there was no criminal activity in Leon County. Nothing happened in Leon County. If the alleged facts are true, the second Mr. Hubbard picked his pen up off the page after signing the document, that crime was complete. The second he filled in the bubble on the voter card, that crime was complete.
And you would concede he could have been charged right then, arrested right then, correct?
He could have. In fact, I'll go one step further. Let's say that there was an organization who was collecting voter registration cards, and they had a stack of them, and they brought them back to the office, and Mr. Hubbard's fell off the top of the desk and went underneath. The rest of them got sent to Leon County. 3 months later, they find Mr. Hubbard's. He's still potentially guilty of this crime because it finished on the signing. Nothing in the statute in which he was charged with requires any conduct in Leon County whatsoever. The problem we have is the state and the OSP is attempting to fashion a situation where OSP jurisdiction exists by virtue of using a ministerial function where the Secretary of State is discharging its statutory obligation.
So what's the test? You say criminal activity.
And
what gives meaning to the word occurred? I think Judge Atkinson in his concurrence frames it as where the elements of the crime occurred.
Correct.
Do you think that where criminal activity and the elements of crime, is there any daylight between there? Is that just 2 ways to say the same thing?
I think it's 2 ways to say the same thing. I can maybe envision a situation where there is still some criminal activity that might not be related. For instance, in the Thatcher case, where the defendant never left Miami-Dade County, but they were importing drugs from, I believe, New Jersey, and the unindicted or the uninformed co-defendant was on a bus with the contraband through the entire state of Florida. So even though that wasn't conduct by Mr. Thatcher, it's still criminal conduct that actually happened in other jurisdictions. Actually, the Winter case is the Snyder case is really instructive because that was a chop shop, right, where the items were stolen in one county to be fenced or sold in another county. And then in the same county, there were also burglaries, totally local burglaries, that the OSP put in there and charged with. And the court said that's okay because it was all part of this related transaction of making sure this enterprise of the chop shop stays afloat. And so that you couldn't separate them. But still, the moral of that story and the moral of King and is that a crime or criminal activity actually occurred in both circuits, which is the necessary thing that's the necessary border of the constitutional box in which the Florida Constitution places the Office of Statewide Prosecution. The whole point of the Office of Statewide Prosecution, if you look at some of the amicus briefs, is that the Florida decided, the various states' attorneys decided it was really difficult for them at the time to prosecute cases that spanned, especially in organized crime, that spanned circuits. That was the genesis of this complex RICO, complex organized crimes that span circuits in order to more easily and effectively prosecute them.
I mean, the challenge for you, though, is that I think it can't be disputed that the language is broader than what appears to have been the motivation for the creation of the office. Like, it seems like all the materials are organized crime, organized crime, organized crime, and yet the words here in the Constitution are not limited to that, which is what has led to this dispute, right?
Yes, except the one issue that's not in dispute is the multi-circuit aspect of it. And when we look at the case law that addresses what the related transactions in multiple circuits are, there is always a situation where in that other circuit, criminal activity happened.
I know you're already into your rebuttal, but could you just briefly address why the 2023 amended statute would not apply to Mr. Hubbard?
Several reasons. One, it was enacted after the dismissal. Two, under seven.
Let's stop you right there. So this is dismissed without prejudice, right?
Yes.
Okay. The statute of limitations has not yet run, right?
I don't believe so.
And he's waived speedy trial, right?
I don't know the answer to that question, Your Honor.
What's to stop the state from recharging him pursuant to the 2023 statute?
My next point on that will be Section 775-022 says that any amendment of a criminal statute shall operate prospectively only, whether it's procedural or substantive, unless the legislature specifically says so. And this is a criminal statute without getting too far.
Not really. I mean, this is authorization for the statewide prosecutor. This is not defining a criminal offense.
775-022 says an amendment of a criminal statute that deals with criminal in any way over the crime and the punishment. One cannot have a punishment of a crime without prosecution. Therefore, a statute defining the parameters of who can prosecute when, how, and where is most certainly a criminal statute.
But I mean, in the what he's talking about, though, if it were to be refiled, then that would be a prospective application because it's a new prosecution, and then you would be able to litigate at that point whether what the effects thing is and all that. But that would be the appropriate time to raise all that.
I understand the court's point. I'm not necessarily willing to concede that that's the particular fact, but I see what Your Honor says, and that would be a reasonable conclusion of that situation, yes. But the fact of the matter is we're not there yet. We're here, and we have the constitutional confines of this, and there is no other activity in another jurisdiction, and I'm way into my rebuttal, so I'll save the little time I have left for that. Thank you.
Thank you.
Mr. Chief Justice, and may it please the court, I'd like to start, if I could, with Justice Tannenbaum's question about your jurisdiction to decide this case. So two things on that. Number one, I think the question about the certified question is probably academic because at this point there's an express and direct conflict amongst the districts. So the relevant point in time for assessing your jurisdiction, we think, would be when you issue a decision here, either quashing or approving. So we think you're good on jurisdiction. And the second point on the QPI would be that you could rephrase the certified question if you thought you had to. I agree that it was perhaps inarticulately worded and perhaps too general, but we think that you would have jurisdiction.
But I mean, if the passing on, I mean, I don't want to get bogged down in this, but if the passing on thing could just be fixed by us rephrasing the question, that would kind of do away with that limit on our jurisdiction, right?
I understand that, but I think the court does have this practice of rephrasing certified questions. I think it's a sort of functional approach.
Right. Okay. I
Did
don't
they pass
want
what
to
you
get
think
you
they
off.
passed?
Go
But,
ahead.
but it's not just, and just because it's been the practice in the past. I mean, the fact is that under the 1968 Constitution as amended, the DCA has been made in a bunch of circumstances the gatekeepers for our jurisdiction. So if a DCA certified a question and we said, well, you asked the wrong question, so we're going to do this other thing, doesn't that reanimate the cert jurisdiction that was eliminated in early 1980s?
I think my point about that, Your Honor, is that we know what they meant to certify, and we know they passed on that. But if you have any concern about that, just look to the conflict here, which I think is pretty obvious between the third and fourth and the second and sixth.
So
DCAs.
is the actual question, I mean, is the import of the DCA's decision potentially that there's no distinction between basically any state registration or any voting is going to have impact across circuits? So the question is that true, or is there a distinction between there actually has to be a specific showing across circuits, like opposing counsel has argued, as opposed to if it is a voter registration violation or a voting violation, it necessarily implicates the OSP's authority to prosecute?
Yeah, Justice Tannenbaum, I think the way that the lower court analyzed the question was that if you vote in a statewide election for statewide officer or for constitutional amendments, that will necessarily have an effect across the state. That seemed to be the import of what the court said, and they passed on that question.
Doesn't that render the second part of the statute then superfluous? Why put in the provision about the office shall have such power only when it's occurring across? I mean, why not just list it the way the first part is and dispense with the second part?
So I think the legislature just wanted to be clear that it was tracking the constitutional text, and a requirement of the constitutional text is that you have the related transaction or you have a multi-circuit effect. And now we think it's possible that there are some categories of crimes that will always have a statewide effect, and this would certainly be one of them. So
can you focus on the first thing? Because the effects thing only matters if the 2023 statute applies. Do you agree with that?
Yeah, that's certainly right.
Okay, all right. So
let's start at the beginning.
Let's start at the beginning, because everybody agrees that the occurrence thing is potentially on the table, right?
Yes.
Okay. So
there's no doubt that the occurrence prong
that
was in the
theory
pre-2023
that was the theory
amendment.
under which this person was prosecuted
that's right.
in the beginning.
I mean, obviously I want to talk about both, but on the related transaction prong, I'm happy to lead with that. So we think we've got a pretty clear related transaction here. There's nothing in the statute or the constitutional text that requires that every piece of the transaction be criminal in nature. The Radvars could have said that. They could have said a related criminal transaction through and through, but that's not what they said. So I think Mr. Hubbard's position before today was that the only way you could have a related transaction was if the elements of the particular crime happened in two or more places. I don't understand them really to be making that argument today. I think their argument today is a little bit more like what the second DCA said in Hart, that you have to have a transaction comprised of multiple crimes which happen in different places.
So the way that Trocino makes the argument that, even if the voter registration paperwork had been lost under a table,
right,
you could still charge the person. It seems like he's arguing, in fact, that there is no additional transaction required. The crime is complete. How do you respond to him on that?
Well, that's not, so I think insofar as it goes, that would be true for that particular crime, but it's not true of the entire criminal scheme here, because his objective was not merely to register to vote. He did that for a reason, because he wanted to vote in the 2020 election illegally. The only way that he could do that was if he first convinced state officials to place him on the voter roll. So to do that, he had to submit the false attestation down in Broward. By statute, the supervisors take that information, they send it to the secretary here in Leon County, and there's a statutory process for verifying that information and then putting the person on the rolls here in town. Only then could Mr. Hubbard complete the criminal scheme by going back to Broward and voting in Broward. The entirety of that is a related transaction. As the
So,
lower,
so we have, this is the rare, I know this isn't technically a hearing conflict, but this is the rare situation where we actually have great opinions below that are grappling with the issues directly. And so it's not the usual, like, no one was talking, nobody was talking to each other and we say there's a conflict. So you have the 2nd and the 6th DCA that both seem to hinge their analysis on the idea that the crime has to occur in multiple circuits, and then I guess the 2nd says it can be two crimes that occur in a single as long as they're related, and the 6th is kind of narrower and says that the one crime has to sort of have, be committed in 2 circuits or whatever. So, but it seems like for you have to sort of deal with that issue of the crime occurring in the 2 circuits, sort of to kind of get past them, because it sounds like you're sort of relying on are you saying that the what's happening in Leon is part of what makes the crime occurring, or is that a completely just a related transaction argument?
Yeah, so the way that we read this to give effect to the text about the related transaction prong is that we know the crime has to occur. How does it have to occur? There are 2 adverbial clauses that modify that verb. One is in 2 or more judicial circuits. The crime has to occur in 2 or more circuits. How does it do that? It does it as part of a related transaction. As part of a related transaction modifies the verb in the first adverbial clause. They all work together. If that weren't the case, it would be quite odd so the theory that we understood them to have briefed and that the 6th DCA espoused, if that were the case, that you actually had to have elements of a single crime happening in more than 1 circuit, that would be a vanishingly small number of circumstances. So the King case out of the 5th DCA made this point. One of the original enumerated crimes in the 1985 implementing legislation was burglary. Well, unless the burgled property happened to sit on the circuit line, you would never have a burglary whose elements happened in more than 1 place.
When was burglary amended to include conveyance? Burglary of a conveyance?
It probably did. I'm sure it included conveyance at that time.
So, because there's at least one old case where somebody burglarized a car that moved into a different judicial circuit, and then you look at the statute saying where to charge crimes that have occurred in multiple judicial circuits. So I could see how burglary might fit, even though most burglaries are probably local in nature, within kind of this multi-circuit scenario.
Yeah, Justice Stasso, there might be a home that sits on the circuit line as well. I mean, our point is that that is a true outlier that I don't think anybody in 85 or 86 would have thought the ratifiers had in mind. They had in mind something broader. Homicide works the same way.
I mean, the reason you're bringing this up because the statute lists burglary.
Right. So,
but I mean, the text doesn't, so maybe burglary shouldn't be in the statute.
The point that we're making is that contemporaneously with the enactment of this constitutional text, there was an implementing statute right around the same time, and the legislature understood that burglary would be the kind of crime that you could prosecute under the related transaction prong.
So should we also read the organized crime limitation into the Constitution too?
No, I'm just saying that, a well-informed body, the legislature, looking at this constitutional text, thought that burglary would be prosecutable by the statewide prosecutor. So I just think it's one indication of the meaning of the text.
It just feels very different to say, even under yours, where you have burglary, maybe they're fencing the items in another place, and maybe they're transacting money in a conspiracy in another place. I mean, I can see how there might be individual offenses that are happening in each circuit, but it's part of a related transaction, and perhaps that would be it. What you're saying is someone committed a crime fully. All the elements of the crime were met the minute they signed the thing or went in to the polls, but yet because of a sort of administrative aspect that this person technically had nothing to do with, that somehow ropes this into being a related transaction. And I think that's where we're all having a little bit of a difficulty. That doesn't seem to be offense is occurring or has occurred in 2 or more circuits.
Right. So
I would say what is the offense that he committed that is occurring at his own behest, other than an administrative checkoff?
Well, no. Look, I think all the parties agree that the elements of the crime happened in one place, in Broward. But as the 3rd District said in Miller, to complete the crime, there were things that were necessary that had to happen elsewhere.
So you could not charge him with this crime if it had not gone to Tallahassee. You're saying the state cannot charge this particular crime if that is not processed in Tallahassee.
At least not under the related transaction theory. Obviously, under the effects theory, we have a broader
you just
claim.
said that he hadn't completed the crime yet. So has he completed the crime or not?
No, what I'm saying is, okay, if you're just talking about the elements of the crime, those elements happened in a single circuit. Our point, though, is that the text is a related transaction. And in order to, and this is what the lower courts that rule for us are saying, in order to have completed his crime in the practical sense, not in the literal sense of where the elements happen, but in the practical sense, he had to get some buy-in from the Secretary of State to verify his information and put him on the rolls. Without that, he literally could not have voted illegally in the 2020 election.
But he could have
That's
registered.
The related
He could have
transaction.
false swearing submission of false voter registration.
Yes, but that is not all that he did. He also then went on to vote, and to vote, he needed the Secretary's acquiescence.
So if someone votes improperly under this law, but for whatever reason, the Secretary of State hasn't processed. So let's say they go in, they say, you're not on the roll, but you can go ahead and cast your vote, right? That happens, and then we'll check it later, right? That happens a lot, I think. Are you saying they didn't commit a crime then because they hadn't been processed in Tallahassee yet?
So I think you do have to be on the rolls. There's a.
She's talking about casting a provisional ballot.
The provisional, you are on the
verified.
rolls.
So you would say the scheme then was completed when the provisional ballot was verified with the help of Tallahassee?
Well, even then, I don't know. No, I would phrase it differently. The transaction was when they put you on the rolls to begin with, because without that, you couldn't even vote the provisional ballot.
So I guess
What happened if Mr. Hubbard had committed a crime?
If he had committed his crime in Leon County, we would be talking exclusively about the effects prong,
Right.
and we would have arguments under the effects prong.
Also, okay, so assuming that statute's not in play, there'd be a crime committed in Leon County that's transmitted to the Secretary of State, who's located right behind us, right here.
No, the related transaction would have happened in Leon County.
Did the legislature intend for Tallahassee to put it from the hands of the statewide prosecutor?
Well,
I mean, the legislature?
This might be a quirk of how the related transaction
Well, they
prong
know all
works.
these things, the legislature. I mean, I should have thought about this.
Just I would just ask yourself, does the text related transaction, was there a transaction here between Mr. Hubbard and state officials? If there was, and if it happened in two places, that's enough.
The only reason we're here, okay, putting aside the 2023 amendment, we're here is because cast his vote in fraud in county, and there was some middle Secretary of State, and that brought in second circuit. Now we have two circuits. Now, our hypothetical, he committed his crime in Leon County, so same county, the transmittal. So did the legislature meant to leave that out? How did that work?
Well, I don't know what they meant, but I know what the words that they used are, and we think that our reading is the most reasonable reading. Now, I want to say one more thing about the related transaction prong, and I do want to talk about the 2023 legislation. So the other theory that's out there in some of the district courts, the second DCA, Judge Atkinson's opinion does a nice job laying this theory out, is that the way that the related transaction prong works, you don't need elements in two places, you need two separate crimes, one in one place, another in another. And he got there by looking at the use of the plural in violations of criminal laws. We think the problem, and so we reasoned, okay, there has to be violations, more than one. We think the problem with that is because the plural always includes the singular. So when the text uses violations, it really just means any violation of a criminal law, and that's confirmed in two places. After the comma, when we get into the effects language, the text uses any such offense in the singular, and that's how the legislature understood it as to both the related transaction and effects prongs in 1985 in the implementing legislation, because it said when any such offense. So the legislature seemed to think you just needed one offense, not more than one.
Why would we not, in defining what constitutes a transaction, look at the statutes of the crimes that were charged to guide us on what the transaction was? And here, if it's just willfully votes or willfully swears or affirms falsely in any oath or affirmation. Why should the statute of the crime charge not be our guide in defining the transaction, as opposed to this kind of bigger picture? And again, effects would be a completely different scenario. But it seems like we have to go beyond the statute that describes the crime to work in this idea of a transaction.
Well, I think sometimes it would be helpful to look to the elements to figure out where the thing happened, but we think that the transaction would not be limited to that. And I think your question kind of assumes the answer to the interpretive question about what is it that we look to figure out where the related transaction is. So for us, it's as simple as, do you think that there was a transaction here between Mr. Hubbard and state officials in Leon County? And if you think that there was and that it was necessary to the crime, then we should win on this theory.
But on that point, there seems to be a little bit of a misunderstanding on how two statutes in particular operate. 102.071, which has to do with tabulation of the votes, and 98.015, which has to do with registration with the supervisors of election. So the supervisor of election is a constitutional officer, and they are made responsible. They're voter registration officers, and there's a whole statute that governs how they do registration. They can have their own software system, and all that happens is that then they have to send the name to a master database that's managed by the Secretary of State. But that's not, and then the confirmation or the issues about whether they're a convicted felon or there's duplicates, that happens after the registration is final. So on that front, it seems like it's done when the supervisor of elections takes that registration. And then on the voting side, the tabulation happens at each precinct. And then the election board for each precinct reports the votes to the canvassing board for the county. And then those votes are then counted and collected and then tabulated into a number. And that's their vote for each county. And then that certification then goes to the Election Canvassing Commission eventually to be then finally canvassed. There seems to be a lot of things that happen in between the actual acts and Tallahassee getting involved in any sort of active way.
Justice Tannenbaum, I'd rely on a statute that's much more immediate and in between all of that, and that's 97.053 sub 6, which says that before you can be placed on the rolls, within a certain amount of time, the secretary has to verify. I think it's like the secretary has 13 days or something like that to verify. And that happens before you can ever vote and before you can be placed on the rolls. It says that a registration application is only valid if the secretary verifies.
Right, but doesn't the supervisor election still put the registration into the system, and then it eventually transmits to the secretary?
But it's only valid if there's the verification. So I think we would rest on that for the application.
Go ahead, please.
But the false statement is made to the supervisor, right?
Yes, but you cannot vote unless you have the verification.
Right. So under that follows with under just the false statement, you were saying that would not be an occurrence. There would be no occurrence jurisdiction of the statewide prosecutor.
I think that's right. Okay. We're not saying that. This is bookended on the one side by the whole scheme is bookended by the false statement and then by the voting.
So if it was just false statement,
what would have happened with just one or the other? I'm sorry to cut you off.
That's okay. So just the false statement, not necessarily, because that's not a Tallahassee involved process.
I don't have to take that on today. I'm relying on the fact that all of this was part of the transaction. Now,
I just wanted to pivot us in a slightly different direction that I think speaks to this a little bit. The word concurrent appears in Article 4, Section 4B. It's concurrent jurisdiction, right? If that word didn't appear and we were speaking only about jurisdiction, perhaps we would have more concern about whether the Office of Statewide Prosecution was displacing the local state attorney's office. My question, my sort of last line of questioning that I wanted to get the state's view on is, do you agree that at most what the Office of Statewide Prosecution has is the same jurisdiction, not any greater jurisdiction than what the state attorney's office has? That's the first sort of thing I wanted to gut check.
Concurrent would suggest that.
Okay, so if that's true, then all of this debate we've been having about, whether it has jurisdiction or not based on the occurrence of a transaction that didn't include criminal elements seems to me I mean, at the end of the day, we're not saying like the crime did or did not happen. We're just saying whether one or two entities have the jurisdiction to prosecute the crime. We're not going to the sort of operational decision of whether or not a crime has been committed. We're just saying, and conceivably both entities could prosecute the crime, right? Like, it'd be an interesting question if both the state attorney's office and the Office of Statewide Prosecution had prosecuted Mr. Hubbard. It would seem to me to be sort of almost like a, discretionary decision about which of the two cases would be allowed to proceed. And that's really what I wanted to end on, is what's the state's position on what would happen if both the state attorney and the Office of Statewide Prosecution had sought to prosecute Mr. Hubbard?
Well, that's an interesting practical question. I think, generally speaking, we would try to work it out and figure out. It might just be a team effort, or we'd negotiate something. But as a legal matter, I'm not sure what the answer would be in terms of how that would shake out if there was some disagreement. But
can I clarify something though? So, under the 6th DCA Ganem view, because you have to have elements or some aspect of the one crime that occurs across circuits, right, then either one of the state attorneys in those circuits could prosecute that, and the statewide prosecutor, under the Atkinson view that you can have Circuit 1, Circuit 2, but they're part of a related transaction, then each state attorney would be limited to prosecuting their one crime. Right?
I'd have to think more about whether that would be correct, but there could potentially be three constitutional actors involved.
You know what I'm saying? So let me ask you, though, and we'll give you 2 minutes to talk about the 2023 thing. If we disagree with you on the occurring in two and the related transaction, do you agree that we could decide basically that this prosecution isn't authorized by the Constitution and sort of leave for another day adjudicating the Atkinson versus Ganem fight over whether it has to be, the two crimes in different circuits that are related versus the one crime in two circuits that also has part of a related transaction?
Like, platonically, could you do that? I suppose, although you would answer the interpretive question, I would think, and in doing so,
we would be answering part of it. We just wouldn't need to lock ourselves in, because you would lose under either one of their approaches.
Right. I mean, I think it might be a bit of an unsatisfactory opinion if you just say, look, the state's wrong. We don't know what the real meaning of the text is. The state is just wrong.
Well, we could wait for a case where it mattered. But anyway, if you could just spend 2 minutes on your 2023.
Thank you for that. So I think the real crux on the effects prong is whether or not the new legislation applies. I think we're on very strong footing that we would have an effect in more than one place, not just statewide, but even just being placed on the rolls or casting a vote. Like, that is a concrete, cognizable effect in more than one place. So it's going to come down to whether you think Chapter 2023-2 applies. And there, I mean, the case law from the U.S. Supreme Court is so persuasive on this. United States versus Alabama is almost on all fours and lays out this background, this default rule against which legislatures act. So in United States versus Alabama, the United States brought a civil rights action against Alabama, and the district court dismissed because at the time, the civil rights laws in this country didn't authorize that suit against the state. For the first time on appeal, after the U.S. Supreme Court had granted cert and right before it argued the case, Congress changed the Civil Rights Act to authorize the suit against the state. And the U.S. Supreme Court said, we are going to apply the law that exists right now, and approved that suit to go forward and had to reverse the lower courts. So that's the background principle, and there are plenty of cases like this, Bruner and Andrus and Landgraf, that we've cited that espouse these principles.
Could you tell me, because this is kind of a very state-specific kind of question of procedure, what was the error that the lower court made that the 4th DCA addressed and reversed?
So strictly speaking, it's an error in dismissing our prosecution.
But they didn't address that, correct? Because they then addressed effects and the new statute, neither of which were available to the lower court.
Well, I think the 4th DCA ruled for us on both theories, But yes, they passed on a question that necessarily wasn't in front of the circuit court because the legislation hadn't happened yet.
So you think that that's kind of an unusual situation for an appellate court to render a reversal based on a complete lack of error by the trial court?
That is United States versus Alabama.
What about
Justice
Love, though?
Sands.
Our case.
Yeah, so I think the way that it fits into the framework from Love, which I think, Landgraf and all these other cases are part of, is that we have to have a prospective application. Our whole point is that this criminal prosecution is not over. It is ongoing. We are still prosecuting him. We just happen to be appealing a dismissal order, but a criminal prosecution is not final even when there is a conviction until the appeal. So this is still very much a live issue, and all we are asking the court to do is recognize that in an ongoing prosecution, if there is a statute that grants jurisdiction, it applies, as in Alabama, as in the many jurisdiction stripping cases that are out there, like Bruner and Andrus. So we think that's a fairly well settled principle. Landgraf said that the court had regularly applied intervening statutes that oust or grant jurisdiction.
So why would we not, though, as the law changes, drop it down in the case, procedurally where it is, as we do in Love? I mean, it seems to be a different scenario than the Alabama case. So in other words, if this proceeding has already occurred, now we're in appeal, it applies going forward, but the, events that happen that would be applicable to, those are done, those are gone. We're not going to retry every case in Florida every time the law changes.
So I disagree that it's different from the Alabama case. In the Alabama case, the federal district court dismissed the complaint because the suit wasn't authorized against the state. And then Congress changed that after the cert grant in the U.S. Supreme Court. And the court said, we're sending the case back, the case can proceed. So I really do think it is on all fours. Now, as a practical matter, and this is one of the reasons that we say this is academic, this might be motivating this whole line of cases. As a practical matter, the worst thing that happens here is you say, well, we're not going to apply it, go back on remand, or no remand, and then we just refile under the new legislation and we get to proceed. And opposing counsel has said that there's not a statute of limitations problem here. So we could do that, but we think that this case law just reflects that there's no need to do that, because given that the new state of the law would apply to any new suit prospectively, you could just apply it here and save everyone the additional labor.
Principle, though, we would have to, it doesn't matter here because of the statute of limitations not running, but there could be cases where it would matter.
Well, I suppose that could be true. I'm just suggesting that this is an explanation for doctrinally what all these cases like Alabama are doing. It just kind of goes
also,
to...
though, I mean, it also gives, ideally this is the kind of thing that would be litigated in the trial court and you'd have to say what the effects are. And, I mean, in a perfect world, you wouldn't be having this kind of appellate court sort of like, oh, no harm, no foul, kind of move on sort of thing. I mean, this is a relatively straightforward case, but you can imagine a lot where it might not be.
Well, I agree, but I think you take the case as you find it, and this is a case where they're disputing the legal consequences of the points that we make, but they're not disputing that the votes were cast and the vote had to be tallied and that there would have been this effect. They just think that's not an effect that's cognizable under the Constitution.
Well, what they're really asserting, I mean, Article 1, Section 15 gives Mr. Hubbard the right to have an information filed against him that is signed by an authorized prosecuting authority. And at the time, the argument was, under the existing law, that the statewide prosecutor wasn't authorized to sign that information, which substitutes for a probable cause determination. So that's the right that's being asserted, and the trial court at the time agreed and said that this information is not authorized in enforcing that right. Now, how would we just say, well, but now the law's changed, and so everything's okay, even though at the time it wasn't authorized?
Well, that's a sort of notice due process theory. You have to be put on notice of the state's theory of jurisdiction. I don't think there's any dispute, Justice Tannenbaum. They're on notice. We've been litigating this since the fourth DCA. So what happened in the fourth DCA, and I know I'm well over my time, but as soon as the law was enacted, we asked for relinquishment to the state circuit court so that we could litigate this question, get a ruling in the first instance, amend our information, do the things that we would do on remand here. And the fourth DCA was happy. It was content to proceed with the appeal. So he's had his opportunity to make every argument that he would have made in the circuit court. He hasn't identified any other claim that he would have raised if he'd actually done this in front of the circuit
But the
judge.
state could have also just dropped their appeal and refiled under the new statute.
Well, we could have done that, but we wanted to press the related transaction prong, and I think there would have been some sort of sticky questions about whether we could do that after having voluntarily dismissed an appeal or that issue was presented. So we did not view that as being a route that we could take.
Does anybody have any other questions? Okay, thanks a lot. We
Thank you very
appreciate
much.
it. Can you put 5 minutes on there total?
I appreciate that, Your Honor.
Thanks.
One of the things that counsel said that struck me is that in order for this to be a related transaction, the Secretary of State had to have buy-in. Now, as Justice Tannenbaum was saying earlier, that they're basically doing a statutory function. Buy-in requires, I agree, let me go and do this. But what it isn't is just a ministerial function. There's no change in circumstances. They're not using any discretion. They're not changing their minds. They're checking a box and sending it off.
Can you address if we found the 2023 statute does apply? So far, your argument for why it doesn't affect is based on kind of this parade of horrible sort of results-oriented. And so I'm wondering what textually, structurally, what would we look to limit effects jurisdiction? And if it's so vague that we can't say that there isn't room for prosecutorial discretion, you're asking us to say something that's essentially unconstitutional. Don't we need to, as Planned Parenthood said, you've already cited that case, kind of find that beyond a reasonable doubt?
Yes, well, I agree with, I think what Your Honor was asking counsel earlier was about the Love case and how Love would control this situation. I
right, but assuming we've gotten past that.
Yeah, then I think the words in statutes have to have a meaning, right? And so if we use the word effect, can the word effect without the difference? Let me step back. The main difference, the only difference between the statute and the 2023 amendment is the removal of criminal conspiracy. Essentially, that was it, and that was done after the legislature realized they must have made a mistake in this case or in all these cases. And so when they took that out, now we're stuck with effects, because that's the operative word here. And words and statutes have to have a meaning. And if they're so ephemeral to where they can cast a net unlimited in an unlimited fashion, then that would violate not only the enabling statute from the Office of Statewide Prosecution's point of view, but the constitutional amendment that created it in the first place. Because, the parade of horribles, as Your Honor put it, is one thing, but they're potentially real, because what we come down to in this case is the constitutional...
we could debate about effects all the time, but in terms of limiting the level of generality that we would apply effects, what would we look to do that, besides if we take out the kind of like results-oriented limitation?
It would have to be something internal in that other circuit that affects. Look, the statute, the legislature in the enabling statute, they have a section about internet crimes. And they said a crime that happens over the internet affects all circuits. They knew how to say that when they amended this. They chose not to.
But analytically, wouldn't your answer have to, in some way, you have to say that, look, you can't read the effects thing in the Constitution so broadly that it makes the first thing irrelevant.
Exactly.
Right.
Yeah.
And so I think that's at least like a possible sort of gateway for you to walk through. But I still think that it's difficult then to figure out sort of how to put some teeth into the effects thing in any kind of principled way. But if it just literally means any effect, no matter how sort of tangential or whatever, then there would be no point to having the occurring in two or more related transaction, whatever. Why bother?
Yeah, and teeth in the effects is an appropriate analogy, because I think the effects, in order for this to pass constitutional law, effects has to have teeth. So it's toothless.
Well, how about this? Would you concede you'd have a stronger case if the election had just been for mayor of Lighthouse Point in Broward County and he'd voted just for that? Would you agree that your position here today would be stronger? Well,
that would be a situation where it was purely in one circuit.
Yes.
But I don't think it changes the outcome of it at all, because it's still, we still need to define effects. What does it mean? What does effects mean? Does it mean that we can have a situation where the 4th District Court of Appeal decided without any record evidence that I'm sure we can all agree, standing here, me standing here, you all sitting here, that fraud in elections is bad and it's a problem. But I don't think we can, other than our gut instinct to say that's got to affect the public's confidence in the outcome of the elections, I don't think we can legitimately make that particular leap here.
Well, but I don't think the state is arguing, although some of the decisions from the DCAs have spoken about public confidence. I want to be clear. My questions are not about public confidence. Okay. It's about outcome determination in an election. I mean, we've had elections decided by 438 votes. So I'm not talking about confidence. My question is sort of, I think, an effort to get you to admit, which I think you have, that in a statewide or federal election, there is a numerical effect on the computation of votes that would be different in that it is statewide from a local election alone. And that would seem to be one line that could be drawn in trying to come up with a line for the effects test. Am I wrong about that?
I don't think Your Honor's wrong, but I think there's a nuance in there, and I'm out of time. So
go ahead. We helped you.
But there's a nuance there in that if we would also need to know for whom this person voted for. If this person voted for a write-in candidate, that doesn't make a difference, even if the margin is 423 votes. So there's a lot of information about the functional activity of this criminal offense that we don't know. And if we take the position that it just sounds bad and it hurts me fundamentally to my core of democracy, that's well and good, but it doesn't rise to the level of allowing the Office of Statewide Prosecution to exceed their constitutional box and prosecute these cases.
Could you please?
I'm not necessarily disagreeing with you, Justice Curiel, but there's a lot of information we don't know in order to get to where you're going.
Yeah, I'm sorry to interrupt you, but last thing, and then obviously if anybody else has anything, but could you address his point about that Alabama case? Because that does, he's saying that they, at the time the United States filed the lawsuit, they didn't have the authority to do it. They gained the authority midway during the appeal. The court said that's fine. Why isn't that what's happening here?
One, it was a civil rights case, so we're dealing with criminal cases. So the protections against for defendants are heightened in situations of criminal cases like the one that we have. Two, I think this court's decision in Love perfectly applies here because that was a midstream case, and then the change in the burden of proof on those hearings was held not to apply, even though it could have gone back and done it the other way. So I don't think the federal cases are applicable in this particular circumstance.
Okay. Does anybody else have any questions?
So in the end,
sure.
Why can it not be that why can't the legislature ultimately determine, looking at the landscape in the state of Florida, identifying maybe there's certain judicial circuits, maybe there are certain state attorneys that don't want to prosecute certain voter registration issues or voting problems? Why can't the legislature say, hey, we're going, because of the importance to the state of Florida to have, fair elections, accurate elections, to say, look, we have this Office of Statewide Prosecutor. We're going to designate that office, which has, basically statewide authority or multi-circuit authority. We're going to designate that office to prosecute these cases when the state attorney isn't going to bring the case, and because it has implications statewide, voter registration and voting in statewide elections.
Because that would be contrary to the constitutional amendment that created the Office of Statewide Prosecution, where it's required to be in multi-circuits. But
the legislature could kind of determine that, say that, well, it does, by definition, crosses judicial circuits in that way.
They had the opportunity to say that, like they did in the internet type cases, and they chose not to. So the doctrine of statutory construction is if they knew how to say it and they left it out, you can come to the conclusion that they intended to leave it out. And I'm well over my time. I appreciate the court's patience. And with that, I'd ask the court to reverse the 4th District Court of Appeal. Thank you.
Thank you. We'll take a 10-minute recess.
All rise.